You still have a narration problem. That's true. And remember, you still have a narration problem with lots of these non-hearsay examples. But what does the rule care about? It doesn't care about narration. It cares about sincerity. So you're exactly right. And you would want to make that objection. You would want to say, no, we should bring the child in because maybe she miscommunicated. But there would still be a legitimate argument for non-hearsay, because non-hearsay says if sincerity isn't an issue, it's not hearsay. Yeah. Uh-huh. Yeah.
So that's, is he trying to prove that through evidence by proving she knows what it's in the room?
Yeah. Yeah, one way to think about it is imagine that you know, the brain is just this gel, this you know, unreflecting gel, and when you see something, you know, that's impressed on your brain, and it doesn't have anything to do with when you talk about it or repeat it. It doesn't have anything to do with your sincerity. You're just like you're a photographic image, or like you're a tape recorder. And when the child says, defendant has X, Y, and Z in her room, all she's doing is telling you the contents of that thing that's stamped on her head, right? Sincerity doesn't interact with that. You're not interested in, you don't care whether she's sincere or insincere. You don't care if she consciously remembers being there. You say, look, she's got this thing in her head that could only have come from the defendant's room. It's kind of like saying, you know, the child has these marks on her back that could only come from a chair in the defendant's room. There's an impression on the child, and that impression is not a hearsay issue. Now, one thing you can think about it, and another way to think about this is it's kind of like a verbal object, right? Remember what you did to establish something as a verbal object? You said, well, we have independent linkage. And so the prosecutor says, look, I'm not offering her statement to prove what's in the room. That would be hearsay. I'm offering her statement to say she has these things in her head, and guess what? I can prove that these things are in the defendant's room, right? So I'm not relying on her assertion that I was in the room. I'm not relying on her sincerity and whether she believed I was in the room. I'm just relying on the contents of her head. And then I'll show through independent evidence the defendant, in fact, has those things in his room, and that is not hearsay. That's hard, but it's a legitimate argument. Let me give you another example, and this is even more common in these kinds of cases. The officer doesn't testify anything about the child's statements with respect to the defendant, but the officer testifies that the 5-year-old described sex in explicit detail, and this is offered by the prosecutor to prove that the child has age-inappropriate, or you might say precocious, not to be confused with promiscuous, precocious sexual knowledge. This happens all the time. This happens all the time, where a child seems to know these things, and you're like, I don't know. Now, it's changed with the unfortunately easy availability and accessibility of pornography to kids, that now kids know all sorts of stuff that, boy, I sure didn't know that when I was 5 years old. But at least if the prosecutor can establish that she hasn't been exposed to pornography, this is a good argument for inferring that she was sexually abused. And notice that we're not trying to prove what sex is. We're not offering this to prove the truth of the matter asserted. We're offering this to prove that the 5-year-old's head has some content in it that proves that she was abused. And if she's just talking about sex, but she doesn't think that anyone's ever abused her, you would still say this suggests that she was abused, right? Because a child's familiarity with something that they should not know about suggests they were exposed to it. It doesn't have to be sex. Sex is the usual case where they try to do these tricky things to get around hearsay issues. Because, of course, as you might imagine, kids are often difficult and often cannot testify. So it could be other things. I mean, a lot of kids now know a lot about methamphetamine production. Why do they know? Well, do you know this? Most methamphetamine production is kind of like mom and pop. Is people in suburban areas with kids build a meth lab in the garage, and the kids come running in and out playing. You know, your ball bounces and it falls into the garage, and you come in and there's dad with the big, pot cooking up some meth. And kids know these things, and the police find out the kid knows, and that's non-hearsay, that the kid knows about meth, which suggests that the parents have a meth lab in their garage. you know, this bumper sticker, ask me about Nutrigrain, or ask me about or ask me about something. Ask me about meth labs. Because it's the new way to get rich quick for the up and coming family. All right, so that's knowledge. Any questions about knowledge? Because I know that's one of the really most difficult non-hearsay examples. But if you kind of understand it as like verbal objects, and if you understand the sincerity argument, then I think you can make a good argument for non-hearsay. And of course, the opponent will say, no, narration is still a problem. Who was it that said that? It's you. You still say those are hearsay dangers. Okay, so you still have an argument. Okay, let's talk about performative statements. Performative statements, we're now going to take a detour. We've been talking about pure verbal statements that are not offered to prove the truth of the matter asserted. And those are interesting. But performative statements are, in some ways, easier because performative statements, and this is according to the book, are conduct in the sense that they do something independent of what they assert. Okay? So when we say performative statements, we mean statements combined with, and this is the way I think about it, they're assertions plus some non-assertive conduct. And it's that non-assertive conduct that allows us to argue they are admissible as non-hearsay. Okay? Actually, in constitutional law, you learn that term speech plus. Yeah? It's kind of like speech plus. And I like to draw a distinction between hearsay and sadu. Right? Hearsay is inadmissible, but sadu is always admissible. And what do I mean by sadu? What did you see him do? Hearsay. No. Non-assertive conduct. I saw him walk to the person's house and give him some drugs. Right? Not hearsay. But if you said, I saw him say, I went to the house and gave him drugs, hearsay. So sadu is perfectly appropriate. Well, it turns out that sometimes you have a mixture of hearsay and sadu. Sometimes doing something says something, right? You know that already. That's when nonverbal conduct can be assertive. That's hearsay. So pointing when you ask me who did it, that's hearsay. Well, sometimes saying something also does something, okay? And this goes beyond verbal acts. With verbal acts, we said merely saying it makes it so. So merely saying it is the action that we're interested in. So I got married, right? I say I do, that's an act. But this is even more than that. Performative go beyond that. And so what you always want to consider whenever you consider any piece of hearsay is you say, is it more than merely words? Is it more than merely words? And if so, then you have a potential non-hearsay argument. Now let me give you a case example. This is U.S. v. Singer in your textbook. And here's the evidence that was offered. They found an envelope addressed to Carlos Almaden and Joseph Szynski, 600 Wilshire, this was an LA case, containing notice to terminate their tenancy. And it was offered to prove that Mr. Almaden and Mr. Szynski lived together. Well, first of all, just use a classic hearsay. You say, is this an out-of-court declaration? Is the envelope an out-of-court declaration, out-of-court assertion? No? Yes? Yeah, right? Writings. So when someone writes on the envelope, they say, Carlos Almaden and Joseph Szynski, 600 Wilshire, are they intending to express that Carlos and his buddy live at 600 Wilshire? When you write a letter to someone and you put an address in the envelope, are you intending to express that they live at a particular place? Yeah, yeah. Sounds like hearsay. But notice that the envelope was not merely, it wasn't merely someone writing something on a piece of paper saying Carlos and his buddy live at this address. They put it on an envelope. They put a stamp on it. They put their return address on it. They put something inside it. They said, Dear Carlos, you're evicted. They did all these things. They sent it to their house. It was found in the house of Carlos and Joseph. Well, don't assume that. That last part is not necessary. They did all those things. And this was accepted as non-hearsay? Well, that seems weird, right? But notice it's more than merely an assertion. And here's how the court and the commentators reason about this. They say this. They say, if this letter were submitted to assert the implied truth of its written contents, that A lived at 600 Wilshire, it would be hearsay and inadmissible. Right? That's the analysis we just went through to say it's hearsay. It may not explicitly say, you know, when you write an address on the envelope, you don't say, Carlos lives at 600 Wilshire. My son does that. He's cute. He's a little kid. So he'll write, you know, my friend Mac who lives at. That's how the way he writes addresses. But you don't have to do that. It's still implied, though. You're clearly intending to express that. But the court goes on to say, but it is, however, admissible non-hearsay because its purpose is to infer from the landlord's behavior, his mailing a letter to A, 600 Wilshire, that A lived there. You see that bright line distinction? So mailing a letter is more than simply writing a statement. Okay? So is mailing a letter non-assertive? Well, imagine a different situation where you don't rely on your communications with the U.S. Postal Service, right? You want to avoid assertions altogether. So an undercover agent gives the owner, right? We want to find out where Carlos lives, and we don't want Carlos to know what we're doing. So an undercover agent gives the landlord a package, and he says, "Can you deliver this to A?" And the owner says, "Sure, I'll deliver it to A." And then the agent follows the owner, and he watches as the owner gets in his car, he follows him down the street, he stops in front of 600 Wilshire, he walks up to the door, he presses the doorbell, someone comes to the door, you see the owner giving this person the package, and the agent says, "Uh-huh," right? That's Carlos. And if the agent testified in court that he did all these things, would there be a hearsay problem? Or could he say, would he be allowed to say, no, this is saw-do. This is what I saw the owner do. And the owner was not intending to express the fact that he was giving a package to Carlos. He wasn't trying to communicate that to anyone. Remember when we talked about non-assertive conduct, right? He doesn't care if anyone's watching, right? He's not being sincere or insincere. He's just taking a package. You want to assume he doesn't know the undercover agent is watching him, right? So he's not misleading him. So notice that the danger of insincerity is minimized. And that's what we said about non-assertive conduct. Non-assertive conduct, you can't be lying because you're not trying to say anything. Now, you'd say, is there still a problem with perception and memory? Could the owner have forgotten or not even know where Carlos lives? Yes. Could there be a problem essentially with narration? Right? Maybe at the door, he wasn't giving it to Carlos. He was actually talking to the neighbor. And he was saying to the neighbor, can you give this to Carlos? So essentially, it's like narration, right? You've misinterpreted his actions. That's still a problem. But hearsay doesn't care. Hearsay says, if it's non-assertive, then it's not hearsay. And here you have a combination, a letter, a combination of assertion plus non-assertive conduct. Courts will let it in. Courts will say, that's performative. At least some courts will let it in. You make the argument. Well, and why does behavior make a difference? Well, in part, it makes a difference because it's non-assertive, right? If you do something, you're less clearly trying to say something, obviously. And in part, it gets into this issue of reliability. And this is, you know, when we get to hearsay exceptions, which we'll get to very soon, because we're supposed to get to that today, what you'll see with hearsay exceptions is that hearsay exceptions start saying, well, maybe we don't care so much about the procedural issues of, you know, can you cross-examine the declarant? Maybe we care about whether these statements are likely to be true or not. And if you do something in addition to say something, it's more likely to be true, right? And these are the expressions, and, you know, colloquial expressions often express profound truths. Right? So we say this all the time. Actions speak louder than words. Put your money where your mouth is. Now, I love this expression because it always conjures up kind of disgusting images of sticking large bills in your mouth. But I think it means something more like, do what you say you're going to do. And my favorite is, you can talk the talk, but can you walk the walk? Right? You can say it, but you can't do it. And if you can do it, then I'm more likely to believe you. Right? Now, before I get to your question, I realize we have the benefit of people from all over the world, LLM students. And I'm sure that in their languages, they have these similar expressions. Is that true? Are there expressions similar to saying it means less than doing it? Because can you tell us how you would, I know it's hard, but how would you say it? How would you say it? Because I'm sure there's something very colorful, like, the chicken rises earlier than the rooster, or some great, no? Well, think about it, and send me the English translation, and I'll add it to the slide. Okay. You're still thinking? Okay. Oh, I'm sorry. And you had probably a legitimate question you want to ask, so we should probably cover that. Yeah. And he hadn't sent it. Right. Yeah, great question, right? Because now you're doing what the professor does when he says to the student, well, what if, and pushing him. Well, obviously he's done less, and there's a greater risk of insincerity, right? It's like you say, is this planted there, right? And so, yeah, so I'd say that would make it less performative and more pure hearsay. Right? And then, of course, you can, what if he hadn't put a stamp on the envelope? And what if he had just left the letter out? So, and you can see why you would say you're less and less confident that it's a sincere, or you're less confident that you can believe it as you take away those little bits and pieces of behavior. But where you draw the line is really up to the court. Excuse me. Okay, let's talk about lying. My husband is in Denver. This is a classic case where the officer testifies that the wife said, my husband is in Denver. Well, that's hearsay, right? Out-of-court declarant. But it's not offered to prove the truth of the matter asserted, because they say, oh, no, he wasn't in Denver. He was found hiding out in a neighboring town. Okay? Yeah, actually, I think the real case was she said he was in Boston, but he was really in Worcester. But that's kind of an East Coast thing. So let's say he wasn't in Denver, he was in Boulder. Okay? And the wife's statement is offered by the prosecutor to prove that she made false statements to the police. And why would you want to prove that? Well, remember flight? Flight is popular. The prosecutor says the police came to the door and he jumped out the window. Shows consciousness of guilt. This is just like flight. Wife covering up for the husband. That suggests that he's guilty. And how can you argue? What's the easy argument to make that it's not offered to prove the truth of the matter asserted? What's the easy argument? Yeah. No, she never testifies. So they want to offer this as substantive evidence of the husband's guilt. It's not just impeachment. So think, what formally is the argument that this is not offered to prove the truth of the matter asserted? Yeah. Yeah. Right. So you say just on the face of it, where it's not offered to prove the truth of the matter asserted, because the matter asserted was untrue. That's it. And most courts will accept that. Most courts will say, and actually the Supreme Court, which really doesn't care about most evidence issues, although they have of late, surprisingly, because of the Confrontation Clause. But usually the Supreme Court was really happy to say stuff like this. So they say, it's not offered to prove the truth of the matter asserted because you're not saying it's true. Now, that's superficially accurate, and that will get you 99% of the way there. But you want to understand the rationale a little better. And it's not so clear it fits the rationale of non-hearsay. Tracy? Mm-hmm. Yeah. So you'd want to challenge where the wife got her information from. Although it turns out that, as you'll find out very soon, there's a hearsay exception for anything the defendant said. So, but yes, if you could establish that she was basing what she said on what someone else told her, then you could argue that that's hearsay and that you have this issue of multiple hearsay. Boy, you're getting way ahead because multiple hearsay we're going to cover in a couple weeks. But let's assume we don't know why she knows that. Now, the more complicated issue is whether or not we are relying on assumptions about the sincerity of the speaker in deciding that this has probative value, right? So remember the problem in the past. The problem in the past was Wendy testifies, Deborah said, Al killed Bob. And you want to make sure you understand this. When you assert that that proves that Al killed Bob, right, when you're using it for the hearsay purpose, are you assuming Deborah was sincere? Yes. Yes. That is the hearsay problem. Because you are basing the evidentiary value on the sincerity of the speaker, and the anti-hearsay people say, that's a problem because we need to test that declarant's sincerity by bringing them into court, right? And that's why when we get to non-hearsay, we say, are you assuming the sincerity of the speaker? And we do this counterfactual where we say, we'll assume the speaker is secretly insincere. If it still has probative value, you're obviously not relying on the sincerity of the speaker to derive probative value, right? So all these non-hearsay examples have said, we don't rely on the sincerity of the speaker. We don't rely on the sincerity of the speaker. Now here you've got the flip side. We're not relying on the sincerity of the wife, but notice what we are relying on. We're assuming that she was insincere. The prosecutor, in order to derive evidentiary value from a lie, has to assume that the person was insincere. What if she was making a mistake? Would that still prove that her husband was guilty? If she was mistaken? Well, maybe. But it seems pretty clear that if in order for the prosecutor to say the wife was lying for her husband, the prosecutor is assuming her insincerity. And the hearsay rule says you have to test sincerity. You can't assume. And so just as you can't assume sincerity in classic hearsay, maybe you shouldn't be able to assume insincerity. And maybe you shouldn't be able to prove lies unless you bring the declarant in, and we can ask her. We can say, did you really mean that? And that's the problem with lying. Lying is a case where superficially, facially, I guess I should say, it's not hearsay because it's not offered to prove the truth of the matter asserted. But if you really understand the rationale behind hearsay, which is that we should not rely on assumptions about the sincerity of the speaker, then lying is a hearsay problem and is objectionable on that ground. But you know what? Try to understand that conceptually, and you have a good understanding of the hearsay rule. But when you get into court, you're just going to stand up and say, it's not offered to prove the truth of the matter asserted, Your Honor, and the judge is going to smile and nod and is going to let it in. Okay? Because that's the way the real world is. But I want you to understand that, because the problem with all these non-hearsay cases is the courts get it so mucked up that if you just read a lot of opinions, you'll get more confused about what hearsay means, right? Like that judge in the city courthouse where I sat as a juror who said, if it's the gist, it's not hearsay. Boy, try to make that consistent with anything else you've ever learned about hearsay. So what I'm trying to get you to do is think conceptually about this stuff, but then go out into the real world and make your lousy arguments, because whatever wins, wins. Okay? All right. So, should we talk about hearsay exceptions? Because it's so much easier than hearsay. Let's see what we can cover in the rest of today that we have. We have a break coming up pretty soon. We're going to talk about prior inconsistent statements. Okay? Now, Patty already mentioned the impeachment issue. Well, now we're going to talk about the use of prior inconsistent statements, not to impeach, but as substantive evidence. Because as I've already anticipated for you, under certain conditions, you can offer prior inconsistent statements, not merely for impeachment, but to prove the truth of the matter asserted. The problem is that prior inconsistent statements have all these additional requirements. It's not any prior inconsistent statement that can come in under the hearsay exception. It's statements that were made at a proceeding, so we have to define proceeding. And we also have to define what is inconsistent. Is it inconsistent if you say A killed B, and then when you get to court you say, I don't remember? Is that inconsistent with saying that A killed B? Well, that's actually a puzzle, and the courts are a little bit uncertain about that. So we'll decide what makes something truly inconsistent. We'll then talk about prior consistent statements. Prior consistent statements are potentially admissible for their truth, but they have their own requirements. We have to consider whether someone has been charged with fabrication, because the basis for admitting prior consistent statements for the truth is that the witness has some reason to lie, and the prior consistent statement will rebut that reason. Okay? And we'll have to consider, well, what statements truly do rebut it? And finally, we'll talk about a hearsay exception called identification. Oh, now you know what? I should have paused at that first slide, because that first slide explained what all of these three exceptions are talking about. These are called the declarant testifying exceptions. And what does that mean? That means the declarant testifies. That's an automatic precondition for all three of these exceptions. Okay? Now, the rules do this weird thing, and you'll see this in a minute when I show you 801D1, the first of many rules. The rules say some statements are not hearsay, and then they list these as not hearsay. Totally confusing. Why do they do that? I can't even remember the reason. Don't think of these as not hearsay. Think of these as hearsay exceptions. When you say something is not hearsay in an exam or in real life, you say it's not hearsay because it's not offered to prove the truth of the matter asserted, or it's non-assertive. When you say one of these things, you say it's admissible as, and you think of it as a hearsay exception. But don't think of these as non-hearsay, because that's just going to confuse you. They are offered to prove the truth of the matter asserted. All right? Okay, so let's read one of the rules, and things will be a little bit clearer. So notice, right away, you've got this weird language. Statements which are not hearsay. A statement is not hearsay if, that's problematic. Ignore that language, not hearsay. Here's where we get into something real. Prior statements by a witness. Now what this does, what D1 does, is it sets up the preconditions for the three exceptions that we're talking about today, okay? So these preconditions apply to the three exceptions, to prior inconsistent, prior consistent, and identification. So the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. And what you want in your notes is 801D1, declarant testifies and is subject to cross-examination concerning the statement. Okay? And these two preconditions will apply to the three exceptions we're talking about today. Okay. So that's the precondition. Now let's do the first of the three exceptions, prior inconsistent statements. Here's the first requirement. The statement is, of course, inconsistent with the declarant's testimony. So here's what you want to have in your notes. Prior inconsistent statement, 801D1A. Now, I've told you this before, right? Have I told you the story when you go to an evidence conference, what it's like? That people don't say things. They just call out numbers. So I was talking once about, this is a problem because of the inconsistencies. And someone raised their hand and said, 801D1A. Right? And I was like, whoa. And another one said, 403. Prejudice. You guys know that one, right? You're already a little schooled in this whole enterprise. So 801D1A. Just say it to me, and I'll be happy. Okay? Your whole exam will just be a series of numbers and subdivisions. And if you have trouble remembering them, you don't have to remember them. You can also say prior inconsistent statement. And the second requirement of prior inconsistent statements is, and was given under oath subject to the penalty of perjury at a trial hearing or other proceeding or in a deposition. That gets pretty wordy. So you just want to write this. And was given under oath at a proceeding. Because the word proceeding is the broadest possible word that clearly includes trial, hearing, or deposition. Okay? So that's the rule, prior and consistent statements. Now, we've seen this before, right? We've seen it before because we just saw it the other day, so hopefully you remember. We know that prior and consistent statements can be admitted as non-hearsay impeachment, right? So Deborah gets up on the stand. Deborah says Al killed. No, Deborah says Jim killed Bob. Deborah's flipped. So we got to produce Wendy to say, no, Deborah said Al killed Bob. Not admitted for the truth of the matter asserted, admitted as non-hearsay impeachment. We shouldn't trust Deborah. She says inconsistent things. Okay. Well, why do we have 801D1A? We already know prior and consistent statements are admissible as impeachment because 801D1A allows statements for their truth. 801D1A says sometimes prior and consistent statements are so good, not only do they prove the witness inconsistent, but they suggest that the witness is now lying and was honest and reasonable and accurate when she made that original statement. Now, of course, not all prior and consistent statements are like that, right? When Wendy testifies that Deborah said that Al killed Bob, Deborah might have been drunk, right, or sleepy. She certainly wasn't under oath, so not all inconsistent statements are going to be admitted for their truth. They have to abide by the rules of 801D1A, right? And here's this language that you see again and again. If a statement is admitted for its truth, they call it substantive evidence. So the court sometimes will say it's admissible as substantive evidence under the provisions of 801D1A, and what they mean is it's not just impeachment. It's not just impeachment. Yeah? I'm going to tell you right now. So another way of saying this is, what's the difference, right? What's the difference between impeachment and substantive evidence? And this, I think, is the easiest way to understand this. And what's your name? Steve. Yeah, thanks. Keep that card up, mister. Okay. The difference is, imagine this. Imagine the only evidence is this. Okay? And we talked about this last time, so you should find this part easy. The only evidence is this. Deborah testifies, I saw Carl kill Bob. Turncoat, Deborah. So the prosecutor has to bring in Wendy, and Wendy testifies, Deborah said Al killed Bob. And this is admissible, right, as impeachment. And if this were only admissible as impeachment, what would happen now if the prosecutor rested? Reminds you last Wednesday, right? What would happen now? The judge would direct an acquittal for Al. Al would go scot-free because there is no evidence, there's no substantive evidence that proves that Al killed Bob. And why is there no substantive evidence? Because this statement was not offered for its truth. This statement was offered to prove that Deborah is an inconsistent witness and should not be believed. When you offer something as impeachment, you're telling the jury, forget everything Deborah ever said, right? That's what impeachment is. But if you get under the inconsistent statement exception to the hearsay rule, in other words, if you offer Wendy's statement as substantive evidence, I should say Wendy's testimony, right? If this is offered as substantive evidence, then the jury could convict. And this is an amazingly great weapon for prosecutors. So in California, the prior inconsistent statement exception is extremely broad. It doesn't require the oath. It doesn't require proceedings. And I learned this when I was a, when I was a young lawyer in dependency court. Because guess what happens in abuse cases? The child gets to trial and the child says, "Oh no, I was mistaken. My dad never did anything to me." And the mom is smiling and nodding, and the dad is nodding and smiling. And you think, gee, I wonder if someone's reached this child, right? Maybe that's why this child is recanting. Well, guess what? In California, you can say to the child, well, didn't you tell the social worker that your dad did these things? Yeah, but I was lying. And then you produce the social worker, and the social worker testifies the child said dad did A, B, and C, and it's offered not as impeachment, but as substantive evidence, and the judge then concludes the child was abused. Doesn't matter if the child denies it on the stand. Okay? That's California. Now, under the federal rules, as you'll see, as we've talked about, there are more rules, but That's pretty powerful when you can admit it for its truth. Yes, Steve?
Make it sound like Wendy's statement is introduced under a different rule.
Yeah, yeah, totally different rule. So if, and it falls under the prior inconsistent statement hearsay exception, provided it meets those conditions. So if this happens, hearsay, no, we're not offering it to prove the truth, we're only offering it to impeach. So it's introduced as non-hearsay impeachment. Here, it's introduced, it is hearsay, and so it has to fulfill one of the exceptions to the hearsay rule to get in, right? Impeachment is a common law, non-hearsay use, which I taught you last Wednesday. Remember, I didn't attach it to any rule. I just said this is a non-hearsay use. And this is a rule. Prior and consistent statements offered for their truth is a rule that's in the federal, okay? Is that clear now? And actually, I really appreciate you asking all those questions because I'm sure everyone's wondering about this. Good. Well, why do we allow this to happen, right? Why do we allow this to happen? Well, think about it. Think about it in terms of the procedural reasons for the hearsay rule, and think about it in terms of the reliability concerns that underlie the hearsay rule. And what do I mean by that? Well, remember the procedural concerns. The procedural concerns are that the declarant should be under oath, subject to cross-examination, right? That's what the procedural concern. The reliability concerns are the concerns that the declarant's perception, memory, narration, and sincerity might be lacking, right? And sincerity, of course, is the most important one. Well, are these statements subject to testing by the adversarial process if the prior and consistent statement exception applies? And stop and think about it. Is the declarant subject to cross-examination? Yes, because these are all declarant testifying exceptions. We're assuming that Deborah takes the stand, which means Deborah can be questioned about her prior statement. So, prior and consistent statement exception says, look, the procedure is not entirely satisfied, right? But she can now be questioned about that prior statement. And of course, these other rules apply, that under oath at a proceeding, which we'll talk about more in a second. And are the reliability concerns satisfied? Well, now you just need to think commonsensically. And think about that child in the child abuse case. Child testifies at trial. She's been subjected to 6 months of getting removed from the home, of getting pressures from the parents, pleas from the father, right? All sorts of stuff has happened to influence her story. And when she talked to the social worker the night that he hit her, do you think maybe that statement is more reliable? Sure, now she's in court testifying under oath, and we've got all the trial process going. But which statement do you trust more? Because we often trust prior and consistent statements more than the statement made at trial, the reliability concerns are satisfied. So the statement, logically was made closer in time to the event because it's a prior statement. And it's often before the distortions. Court appearances are supposed to increase people's accuracy and truthfulness. But in reality, court appearances sometimes scare witnesses off. And that's what the prior and consistent statement exception allows for. And remember, the prior and consistent statement exception under the federal rules has additional requirements that try to make it even more likely that the prior statement was true. Those statements had to have been under oath, right? That's one of the requirements of the prior and consistent statement exception. And why would you require that a statement have been under oath? Well, it increases the likelihood that the statement is true. That's what the oath is supposed to do. It increases people's honesty, okay? Now, Congress also said this. Congress said, it also increases the likelihood that the statement was in fact made. And this is where the issue gets a little subtle, and actually goes back to Abe's question about, well, how do we know the officer is telling the truth? And I said, that's not a hearsay danger, because the officer is a testifying witness. Is this a hearsay concern? Is this a hearsay concern? So when you say you should not allow Wendy to testify that Deborah said that Al killed Bob, Is it hearsay because we might not be able to trust Wendy as to whether Deborah actually made the statement? Is that a hearsay concern? No, it's not at all. It's a concern about a witness's accuracy, and the trial process tests that fully and adequately. Congress didn't really understand that. Congress didn't really understand that. So you should feel very good if you don't understand it. Someday you might be a congressperson, right? But you should understand that the real hearsay concern is whether the statement is truthful or not, and that statement is more likely to be true because the federal rules require it to have been under oath. Yeah? Yeah. Yeah. Good. Well, first of all, under the federal rules, they wouldn't be admissible at all because they weren't under oath at a proceeding. They were made to a social worker on the night of the crime. Now let's move to California. What would happen in California? And you're asking, would you necessarily have to bring the social worker in? And actually, no. If the child acknowledged making the statements in her testimony, that's all you would have to do. And that's actually all I did, because the child just said, yeah, I said it happened. And that's enough. Because remember, hearsay can be proven either through the witness themselves, I said this on some prior occasion, or it can be proven through another witness, the social worker who heard the statement. Okay, let me go over the steps for prior and consistent, and then we'll take our break, because it's already like almost 11:40. Okay, so this is just what you want to make sure you know. First of all, did the declarant testify at this hearing? Declarant testifying exception. Was the prior statement inconsistent with current testimony? Was the prior statement made under oath in a proceeding? And is the declarant subject to cross-examination concerning the statement? If those four preconditions are met, then you're good. Now notice that in order to impeach a witness, you don't have to abide by all four of these rules. You don't have to abide by three. But as you already know, this is necessary for impeachment. And as you'll find out, this is necessary. Before you impeach a person, and we'll talk more about impeachment later in the semester, you have to give someone an opportunity to explain their prior inconsistent statement. But for the truth to be proven, this rule has to apply too. Okay, so let's stop there. When we come back, we'll talk about what is a proceeding and the Smith case. And so come back at about, says 11:38, but it's about 10 minutes, 11:48, 11:50. Testing, testing. Okay. All right, we should get back to work. So maybe you can run back to your seats, and we're going to consider the first question that I would have if trying to understand these four preconditions, and that is, what is a proceeding? And the rule, as I noted before, is a little bit more elaborate than the word proceeding. It says this. It says, under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. One thing you want to make sure you understand is, would this include a grand jury? Yeah. And have you been following the Scooter Libby case? How he forgot. His defense is, I forgot. Not I forgot that lying to the grand jury is a crime. That defense has long been discarded. But I forgot that, that I didn't, in fact, learn this crucial detail about a major effort to undermine the credibility of a man. I didn't really learn it from the CIA itself. I learned it from some reporter. So anyway, and he was going to actually testify. He was going to offer eyewitness testimony. An expert, Beth Loftus at UCal Irvine, who's a famous psychologist, was testified at a preliminary hearing to offer support for the forgetting defense. That when you're chief of staff for the vice president, you're so busy, you do forget these things. But they didn't allow the testimony. But anyway, I'm sorry, that's total detour. It does include grand juries. Does it include police investigations? Well, maybe, maybe not. Now, I had you read a case, Washington v. Smith, which says it does. And hopefully, if you did your reading, the reading says it doesn't. So let's look closely at what Washington v. Smith says and talk about whether we buy it. And here's the situation in Washington v. Smith. July 10th, 6:30 a.m., Rachel Conlon is brutally beaten. An hour and a half later, in the hospital, she identifies a Mr. Nova Smith as her assailant, and she tells the officer, I'm afraid, I don't know what to do. The officer encourages her to pursue prosecution of Mr. Smith, and at noon, complying, she goes to the police station, she writes and signs a statement identifying Smith as her assailant. Okay? So within, few short hours, she says, Smith did it, Smith did it, Smith did it. That afternoon, Conlon, chased by one Mr. Nova Smith, runs into the manager's apartment where she lives, screaming for help. Okay. And at trial, she identifies Mr. Gomez as the assailant and claims that Mr. Nova Smith did not attack her but came to her aid. So, typical case. This happens all the time. This is a case of pimp and prostitute, but you see these kind of cases with abusive husband, abused woman, cases I saw with abuser, abused child. You get to trial and the main witness, the victim, flips. Prosecutor, of course, is a little upset about this, asks her whether she made these prior and consistent statements. Didn't you identify Mr. Nova Smith as your assailant? Yes, I did. She acknowledges that. She explains that she was mad at Mr. Smith regarding a fight they'd had, and that's why she falsely accused him. And the prosecutor presents evidence that she lived with Mr. Smith after the attack, and that while he was in jail, she brought him $150 for cigarettes. Okay. And it's funny when you read Smith because, Smith is so euphemistic about all this stuff that you could read it and think like she, sold shoes for Mr. Smith or something. But anyway, that's not the way it was. So should we allow those prior statements to come into evidence? And you can feel the pressures on the court, right? The court is looking at this, seeing this as a clear-cut case of witness intimidation. And we're going to talk a lot more about witness intimidation when we get to the Confrontation Clause, because this is what the Supreme Court now is grappling with in toughening up on the hearsay rules. The court wants to let these prior statements in, but they have this requirement that the statements be made under oath at a proceeding. So that's the situation. Well, first of all, are the statements reliable? Because remember, as soon as we start talking about hearsay exceptions, we talk both about the procedure, as the declarant cross-examinable, And we talk about reliability, because if we believe the statements, then we don't have to worry about the hearsay infirmities. Well, obviously, you can argue they're near in time, less likely distorted by fear of Mr. Smith. She understood, this is a quote from the case, that by giving a voluntary sworn statement, criminal action against the defendant was likely. So she realizes the seriousness of her allegations and nevertheless makes them. She wrote the statement in her own words. She signed each page and the detective witnessed her signatures. And before a notary, she was read the statement, read the affidavit and the oath, and she signed. Okay? Well, what more could the detective have done? Right? What more could the detective have done? The problem is, though, is this a proceeding? When you go into a police station and go through this procedure. It's a procedure, but is it a proceeding? Do you think it's a proceeding? How would you argue? If you're the defendant defending Mr. Nova Smith, he probably gives you part of his $150 as a retainer. What do you argue for Mr. Smith? How do you argue this is not a proceeding? Well, you probably cite case law, because just about every case that's considered this says this is not a proceeding. This would not count to allow the statements to come in as prior and consistent statements. Right? And that a proceeding assumes some sort of administrative or judicial hearing. Right? So what the police maybe should do is, when they get cases like this, is instead of bringing the woman into the interrogation room, they should have a little, like, elevated seat set up. And they should have one of the officers put on a very, a very official-looking uniform, maybe even a judicial robe. And he should bang a gavel, and then he should say, okay, tell me what Mr. Smith did to you. But that's the kind of formality that the courts will require. And that's what a proceeding really is. You can always argue Smith, though, if you're in a jam. Okay, so that's step number one. What is a proceeding? 2, what is inconsistent? Well, inconsistent, it seems obvious, right? This prior statement is inconsistent. But the problem is that inconsistency is easy to imagine, right? You can imagine the prototypical case. Al killed Bob, Carl killed Bob. Are those inconsistent? Well, yeah. Particularly if when she says Carl killed Bob, she says Carl, not Al, killed Bob. But the trial testimony might not have to literally contradict the prior statement. And in fact, and this again is a quote from the, I think this is from the advisory committee notes, but it summarizes what you read in your book, is that inconsistency can be found in lots of different ways, not merely clearly logically incompatible statements. So inconsistency may be found in evasive answers, silence, or changes in positions, of course. A purported change in memory can produce inconsistent answers. A purported change in memory. So imagine that Ms. Conlon, instead of coming in and saying that Mr. Gomez attacked her, if she simply refused to respond to the prosecutor's questions about who the assailant was, would that still be inconsistent? Probably so. What if she said, I don't remember what happened, I was beaten so badly? And this actually matches a case that we'll read later in the semester. Well, if she says that, then the judge has to decide whether this is a purported change in memory. Now that's curious, right? Why wouldn't any change in memory suggest inconsistency? Why wouldn't any change in memory suggest inconsistency? Well, the reason that goes back to the reason with the primary concerns over the hearsay rule, is the emphasis. If forgetfulness must be feigned, right, the emphasis is, what is the worst thing that a witness can do that then justifies the use of the prior inconsistent statement? What is the worst thing the witness can do? Is the worst thing the witness can do to simply forget? No. The worst thing the witness can do is lie. And so if we think that her inconsistency, as revealed by her trial testimony, is insincere, if her forgetfulness is feigned, right? Feigned means faked, false, insincere, then we should allow the prior statements to come into evidence. So again, this whole thing about sincerity as the key component, the key concern, not only applies to our definitions of hearsay versus non-hearsay, but also applies to some extent to our applications of hearsay exceptions. Now, there may still be an objection, though. So let's say you're Mr. Smith, and you know what happens sometimes in these cases is a defense attorney will talk to the victim, and the defense attorney will say things like, you know, if you don't show up, they can't prosecute, right? So he'll give her some friendly advice about some strategy she might use. Or he might say, you know, if you don't remember anything, that will really help Mr. Smith. Now, I'm not suggesting you lie, but just so you know the rules of the game. Well, is there an objection then if she complies, or let's say if she thinks of this on her own, and she says, I have no memory for anything that happened? Is there any objection under the 4 preconditions for the prior and consistent statement exception? And there is, because remember, one of the preconditions is that the declarant has to be subject to cross-examination regarding the statement. Okay? The declarant has to be subject to cross-examination concerning the statement. So what you can argue is, you can say, if you're the defense attorney, you can say, look, because she says she doesn't remember anything, I can't cross-examine her, right? I can't cross-examine her, and therefore the preconditions for the prior and consistent statement exception are not met. Now, here's where the courts start to kind of push back, right? Because as I've been, maybe I'm exaggerating this situation, and maybe I should be more sympathetic to the defense in some of these cases. So many of these cases, though, are such egregious cases of witness manipulation that I feel angry about them. But let's say the courts are saying, no, we're going to apply this rule. We do want the person to be subject to cross-examination. But then when they come to the same conclusion that maybe this is witness manipulation, then they start easing up a bit. And here's where they ease up a bit. So and this is the Supreme Court because they tend to be pro-prosecution, they say that if the declarant is subject to cross-examination, that the rule for prior and consistent statements is fulfilled as long as she willingly answers questions. So she doesn't have to say she remembers anything. All she has to be able to do is to answer questions. And those answers can be, I don't remember, I don't remember, I don't remember, I don't remember. That's enough, okay? That's enough. And what the Supreme Court has pointed out, and we'll see this later in the semester, they use this as a basis for arguing that under the Constitution you're subject to cross-examination if you willingly answer questions, is, as they point out, that cross-examination can still reveal other problems with the witness's testimony. So they can reveal bias. The fact that she says, I don't remember, I don't remember, I don't remember, undermines her credibility. And the defense attorney can say to the jury, you have no testimony in this trial proving that my client assailed this woman, right? So that's it. That's all I'm going to say about prior and consistent statements, unless there are some questions. And we'll move on to prior consistent. Yeah, Emmett.
Situation where the defense lawyer says, gives those hints to the accuser.
Mm-hmm.
That's definitely an ex parte. That's unethical, and we can get in trouble for that, right?
Yeah. So unless he has permission to contact her. So who do you suppose ends up telling her this advice? Yeah. Right, and I'm not advising you to do any of these things, of course. I think it's reprehensible, but, Okay, thanks for pointing that out. Okay, let's talk about prior consistent statements, another exception to the hearsay rule. Prior consistent statements. Actually, and we'll talk about that more, Emmett, because I think when we talk later about it, what's going to happen nowadays is there's essentially a new exception that's gaining vogue, which is essentially a witness intimidation. And my argument is if you can prove any contact between certainly the attorney, but any contact between his client, the defendant, and the victim, then that should be presumptive that there was some manipulation. The problem is going to be proving what that content was, because, of course, if she flips, she's not then going to come into court and acknowledge having talked to Mr. Smith and acknowledge having been coached what to say, right? So that's the real paradoxical thing about this, is how do we guard against that kind of manipulation? So So prior consistent statements is the second exception we'll talk about. I think we'll probably not get to everything today, since we had to get backed up a little bit with the hearsay issues. But we'll do what we can. Here's the rule. The statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive. And what you want to have in your notes is this: statement consistent with trial testimony and rebuts, in parens, implied or express, charge of fabrication, improper influence, or motive. All right? So statement consistent with trial testimony and rebuts charge of fabrication, improper influence, or motive. Pretty much had to write down everything in that rule, but this is all important. Now, here's the steps. I'll give you the 4 steps. They're going to be largely similar, because remember, 801 declarant, testifying exceptions have several preconditions that apply to all 3. So here's what you want to say. Did the declarant testify? That's step 1. Was there an implied or expressed charge of fabrication, improper influence, or motive? That's step 2. Does the prior statement rebut that charge? And is the declarant subject to cross-examination concerning the statement? Okay? And as you'll notice, 1 and 4 are the overall requirements. 2 and 3 are the ones that are specific to prior consistent statements. All right, well, first let's figure out what implies fabrication, improper influence, or motive. And you want to stop and say, what is the unifying theme there? Somebody is fabricating. What is fabricating? Kind of like lying. Isn't that a synonym for lying? What is improper influence? What is someone trying to do when they improperly influence you? What are they trying to get you to do? And what does motive usually mean? Well, hopefully you're thinking a word. Are you thinking the word I'm thinking? Let's figure out if we can ask some questions, and you tell me, are these implying fabrication, influence, or motive? You're the brother of the defendant, aren't you? Is that suggesting fabrication or motive? Yes. Right? So notice it doesn't have to be in a direct assertion. You're lying because you're the brother of the defendant. You can just be, hey, you're related to this guy, aren't you? Yes, but I hate my brother. Didn't you speak to the defendant's attorney this morning? Yeah. But we talked about the weather. You forget things quite often, don't you? Notice that fabrication, improper influence, or motive doesn't say forgetfulness. So this would not count. Now remember, to even get in the door with prior consistent statements, you're going to have to prove first that the person against whom the statement is offered attacked the declarant witness's credibility. And this would not be considered an attack in that sense. You can honestly forget. You weren't wearing your glasses that day, were you? This does not suggest fabrication, influence, or motive. This goes after the person's perceptions. And what about this? What if you simply ask the person, and remember, prior consistent statement can come after prior inconsistent statements, right? Prior consistent statement can be a response to an argument that the person was inconsistent. So the defendant might have asked, didn't you testify at the preliminary hearing that his hair was brown and not black? Right? A question about a prior inconsistent statement maybe suggests that the person has been influenced or is lying, but oftentimes no. Oftentimes you're simply saying that the person is inconsistent for reasons unrelated to insincerity. Okay? So this actually, you have to stop and see. Now, usually, I think in a real case, there will be some charge, some claim of lying or evil motives on behalf of someone else, right? Because that's where we really get our, juries like to hear about that. So usually there will be an attack. But a carefully phrased question can avoid such an attack. Well, let's assume that you are charging the person with fabrication, improper influence, or motive. Now, when does the prior statement rebut the charge? And this gets us into Tomei, right? Tomei was the Supreme Court case in the additional reading packet that you read for today. And here's an example. So let's say day one, Susan said, this is a dog homicide case. Susan said, David killed the dog. All right? And then on day 10, David's enemy, Frank, gives Susan a new car, telling her her statements against David will be very helpful. Now, she's already said David killed the dog, but someone comes in and says, keep her from flipping, says, yeah, this is good stuff. Here's a new car to prove that David killed the dog. And then on day 20, Susan reiterates David killed the dog. And at trial, Susan testifies David killed the dog, but she admits on cross-examination that Frank gave her a car. Now, when she admits that Frank gave her a car, does that suggest improper influence or motive? Clearly, yes. So that opens the door to prior consistent statements that rebut the charge. So the attorney for Susan, the attorney who's arguing that David killed the dog, offers her prior consistent statements, and the issue is which of these statements rebuts the charge. And Tomei comes up with a very simple, deceptively simple, because how do we know this was on day 10? But assuming we know, the deceptively simple rule is this. This rebuts the charge because it occurred pre-motive or influence. This does not. Day 1 is admissible. Day 20 is not, as prior consistent statements. That's simple. And the rule is, according to Tomei, that out-of-court consistent statements made after the alleged fabrication or after the alleged improper influence or motive arose are not admissible. All right? It's nice when you can simply say a court holding. Justice Kennedy? Elegant, simplistic, easy to understand. The problem is this, does that mean that the day 20 statement has no relevance at all? Like, if you're trying to decide if David really did kill the dog, and you hear that not only did Susan say it before she gets this bribe, but that she continues to say it, and she says it not, in any context where, like, a judge is listening or a jury is listening. She just continues consistently to reassert this truth. Do you think that day 20 has no relevance in convincing you that David killed the dog? Do you think it's wholly swallowed up by the fact that she's been bribed? And imagine situations where the bribe maybe isn't so powerful, right? Don't you think that post-motive statements can contribute to your belief in the truthfulness of the original statement, right? Or the truthfulness, I should say, of her trial testimony. Well, the court, if you think that's not relevant, then actually you disagree with Justice Kennedy. Justice Kennedy says there may be cases where out-of-court statements that post-date the alleged fabrication have some probative force in rebutting the charge. So he acknowledges that they have some relevance. He says, but they're not as relevant, so we're going to eliminate them. Okay. Here's where it gets complicated. The court does not talk about non-hearsay use of prior consistent statements, right? And do you know what that is? What is a non-hearsay use of a prior consistent statement? Well, I didn't explicitly teach you that, but remember the non-hearsay use of a prior inconsistent statement? What's the non-hearsay use of a prior inconsistent statement? Deborah says different things at different times. Because she says different things at different times, she is inconsistent and therefore cannot be believed. So what would be the non-hearsay use of a prior consistent statement? What would be the non-hearsay use of a prior consistent statement? Yeah. Yeah. She says consistent things at different times, and therefore she can be believed. And could you offer then, when we go back to our example, could you say, Your Honor, I'm offering day 1 as substantive evidence under the prior consistent statement exception. But I'd like to also offer day 20, not for its truth, but to prove that she's consistent. And this will be rehabilitative in assessing her credibility. Does that sound like a plausible argument? Now, does it sound plausible only to Joel? This is the other question. Do other people think it sounds plausible? It is. It has been. And it's commonly accepted. And Kennedy just kind of forgot about it. He didn't explain whether he thought that Rule 801 D1B, is it, could merely regulate the substantive use of prior consistent statements, or whether it regulates the rehabilitative use of non-hearsay prior consistent statements, or what happens in those cases. It's unresolved. I don't think Breyer talks about it. Breyer mentions it briefly in the dissent, but doesn't really push on it. So you want to remember this. Prior consistent statements might get to the jury as what we call non-hearsay rebuttal or non-hearsay rehabilitation. And 801D1B, the prior consistent statement exception, only restricts their use as substantive evidence. All right. So Tomei leaves all sorts of questions unanswered. First, what about that memory problem? Remember, we said the memory problem doesn't even get you started on 801D1B, right? If you say you don't remember things very well, you're not attacking the person on the basis of fabrication, so you cannot use the statements, the prior consistent statements, as substantive evidence. But now that you realize you can use them potentially as non-hearsay rehabilitation, maybe if the cross-examining attorney says you don't remember things very well, you can offer prior statements not for their truth, but to prove consistency. And certainly it helps you with rebutting the memory allegations, right? If you say you don't remember things very well, and you're able to prove that on day one you said David killed the dog, memory is fresh on day one. Tomei does not even talk about that. But the answer is probably. Probably you can use them as non-hearsay rehabilitation. All Tomei does is say, but they're not admitted for their truth, right? They're not admitted for their truth. And a tougher question, can those post-motive statements still be admitted as non-hearsay rebuttal? So let's say the attack is on motivation. You're clearly post-motive, so you're clearly not under 801D1B. But you say, Your Honor, I'm not offering that for its truth, I'm offering that for consistency, which is what Joel's argument was, right? Can you do that? Well, here it's dicier. Maybe. The answer is maybe. The court suggests that they're irrelevant. Kennedy suggests they're irrelevant. But then in the next breath, I showed you that quote, he says, well, maybe sometimes they're relevant. So no one knows. And you might say, who cares, right? And this is often, when I get confused, I often stop caring. So I totally understand that attitude. And the reason you should care, other than understanding the rule, the reason you should care is, imagine what a jury does with this information. Do you think a jury understands the limiting instruction? It's hard enough for us to come up with the argument, right? So now you get in, let's say Joel wins his argument, and you get in the day 20 statements as well as the day 1 statements. And the jury is told, okay, the day 1 statements you can use for their truth. But the day 20 statements you can't use for their truth. You can only use them to assess the credibility of the witness. Do you think any lay juror is going to say, okay, I understand, right? The jury nods. They nod off as much as nods. And you get it in. So if you get it in, man, it doesn't matter if you get it in as non-hearsay or as hearsay or as substantive evidence or as non-substantive evidence. You get it in, and the jury hears it, and they use it, and you win. So that's why you want to understand this stuff, is you want to understand the strategic ways in which you can say, this isn't offered for its truth. This is offered as non-hearsay rehabilitation, Your Honor. And if you say it in that authoritative way, a lot of judges are going to nod just like the jury does, okay? So that's why it's important. All right, I got to stop because it's 12:20. So obviously we're a little backed up. We still got some more of this stuff to cover. But what I'd like to do is to forge ahead in terms of giving you the readings, giving you the slides, and we'll catch up over the next few days. So I'll see you on, what's today, Wednesday? See you on Monday.